On behalf of the Brennan Center for Justice, welcome. The Brennan Center is a nonpartisan law and policy institute affiliated with NYU Law School, and I'm Alicia Bannon, the managing director of the Brennan Center's Democracy Program, where I lead our Fair Courts team. And we are delighted to welcome you to day one of a two-day convening on issues of workplace equity and accountability in the judiciary. The judiciary isn't only a legal institution, it's also an employer. And in today's panel, we'll be discussing how to address sexual and other forms of harassment in the judiciary. And in tomorrow's panel, we'll look at issues of diversity in law clerk hiring. We're grateful to the co-sponsors of this event, the National Women's Law Center, the NYU Law Review, and the NYU chapters of the American Constitution Society, the Latinx Law Students Association, the South Asian Law Students Association, and the Black Allied Law Students Association. We also want to extend a sincere thank you to those who planned and shaped this event, including Jana Adelstein, Caroline Fredrickson, Emily Martin, and the Brennan Center's events team, Melon O'Keefe and Adrian Yee. I'd like to invite those who are listening to share your questions for the guests by typing them into the Q&A box, and we'll take as many as we can during the program. For those who are seeking New York State CLE credit for this event, we will be sending you at least one unique code in the chat during the program, so make sure you write that code down. You can find the link to the attorney affirmation form and the associated readings in the Zoom chat, as well as on the Brennan Center event landing page. If you have any questions, you can contact cle@brennan.law.nyu.edu. And now I'm delighted to turn things over to our moderator, Emily Martin, who's the Vice President for Education and Workplace Justice at the National Women's Law Center. Thank you so much.
Thank you, Alicia. I'm really excited to be here today and to be part of this important and I hope fascinating conversation. So I'd like to start by introducing our esteemed panel. Please welcome Judge M. Margaret McKeown, Court of Appeals for the Ninth Circuit. Hai Feldblum, the former commissioner of the Equal Employment Opportunity Commission. Elizabeth K. Peck, the Assistant Dean for Judicial Engagement and Professional Development at Cornell Law School, and Diva Shah, the co-founder of Law Clerks for Workplace Accountability and an associate at Kecker, Van Ness, and Peters. Thank you all for joining us today. So after Me Too went viral, there was attention to the problem of harassment sort of across the culture, across occupations, including attention to the problem of harassment in the federal judiciary and the need for better systems to prevent and respond to harassment by federal judges. And that has led to some important changes and reforms in the past few years. But before we dig into those, let's start by stepping back a little bit, because understanding the dimensions of a problem are really important for identifying and measuring solutions. So, Hai, could you start us off by talking through what are some of the institutional risk factors for sexual harassment and how the federal judiciary measure up against those risk factors?
Sure. And by the way, thank you, Brennan Center for Justice and all the co-sponsors for doing this panel. It's just really awesome. So a lot of what I'm going to say here starts from the 2016 report that we put out from the EEOC about thinking how to prevent harassment in the workforce. And one of the things we did was actually come up with a chart of risk factors, why those factors cause risk and possible responses. And you can find that easy, just Google EEOC Task Force Harassment, it'll come up. So here are some risk factors. And just because there's a risk factor doesn't mean there has to be harassment. It just means there needs to be intentionality on that risk factor. So number one, power dynamics. And let's be real, there are power disparities in any workplace. But in some workplaces, there is really a significant, palpable power disparity. And therefore, some people, not all, not many, but some people may feel they can do anything. We see this in clergy, we see this in professors, we see this in some top executives, And obviously one can see that with judges. 2, control over careers, especially with law clerks. This is where they're beginning their career. We see this actually a lot with science labs and professors. This is going to be the reference. 3, decentralized workplaces. We found this often. Headquarters has all the best procedures and policies and values. And then if people have a decentralized workplace, if they have someone who basically can run it like a fiefdom, that's a risk factor. And finally, no tradition of regular cultural surveys or assessments. Some workplaces have been doing this sort of on an ongoing basis. It's not something we've seen in the judiciary. And then, by the way, something that's unique to judiciary, which I know we'll talk about, no coverage under Title VII, which was not a risk factor we put in our EOC report because it's not quite usual.
That's really helpful for seeing the judiciary as a workplace that is affected by the same sorts of dynamics that we see in other industries rather than some completely unique island as we're thinking about this problem. But Diva, what do you think does make the judiciary potentially a uniquely tricky institution to hold accountable for sexual harassment, especially sexual harassment of law clerks?
So I think from a general perspective, reporting is always hard. And so that makes it difficult. That's not specific to the judiciary, but it's particularly acutely felt, I think, for law clerks because the norm is silence. And the norm is silence for many reasons that sometimes are necessary, such as not talking about cases, not talking about the work that you do with your judge. But that sort of norm of silence can also make it difficult to want to speak about anything that happens in chambers, even when there are ways that you can do so, or there are avenues to report. I'll highlight something that Hai said, which is the power disparity. And is highlighted by the fact that so many law clerks were recently law students. And so there's almost a godlike nature to sometimes meeting these judges, meeting the people who you've read about in your textbooks when you are a law student. And there's an element of deference that is warranted to judges for obvious reasons, but it can also lead to deference in employment relationships and almost an over deference in thinking about how to report. So I'll also add that the stories we tell about judges, the Harvard Law Review had a piece on this that said that the lionizing and idolizing of figures can make it difficult for victims to come forward because you elevate judges and sort of erase their complexity as human beings. And then also that when we rely on judges as employment screeners, we also blur the deference given to judges in their role as jurists with the deference that we give to judges in their role as employers. And that can also lead to concerns like Hai mentioned about how we give judges a lot of value in terms of giving employment reviews, and that's important, but it can also lead to some difficulties in wanting to report misconduct if you either experience it or witness it.
Yeah, and as Hai mentioned, one of the other parts of the law clerk judge relationship, which is relatively unusual, is that the legal processes that generally apply if you work for an employer, at least an employer with 15 or more employees, don't really apply if you work for the judicial branch. Title VII doesn't cover you. You can't bring an EEOC charge alleging harassment and discrimination. And if you're clerking for a federal judge, you don't really have a traditional human resources office to turn to in chambers. And so it can be hard to know where to go for help. Though, of course, in the corporate world, HR isn't necessarily a trusted resource in any case, but even that sort of complicated relationship that people have with HR is not really there if you're clerking. But there are just some systems that are currently in place to try to solve for these problems. The federal judiciary has taken steps to try to ensure that there are resources and options available. Judge McEwen, can you walk us through the steps the judiciary has taken to address harassment, and what the landscape does look like today, what options are available to law clerks and other judicial employees who experience harassment?
Yes, thank you. And thank you to the Brennan Center and all of the sponsors. This is a really important topic. So I'm happy to be here to talk about the judiciary. Before I talk about a number of the things that the judiciary has done, I just want to correct one small point. You suggested there's not traditional HR offices. Well, we work, of course, in a chambers, you only have about 5 people. So you wouldn't expect an HR office for 5 people. But every court unit, and every circuit has HR functions and HR offices that are available. But what I'm going to talk about is really what supplements those. I think that the events of late 2017 and 18 were a wake-up call for the judiciary on these issues of harassment. And within days of the initial allegations, our Chief Judge, Thomas, appointed a workplace conduct committee, which I chair. And then soon after, Chief Justice Roberts appointed a national committee, which I'm also a member of. And he's continued to highlight these issues in his year-end address. So the first thing we did in the Ninth Circuit was take a survey of our 6,000 employees. And I want to point out that in the Ninth Circuit, we have about 6,000 employees, including clerks. And nationally, the judiciary has about 30,000 employees. And of these, probably less than 20%, about 19% are clerks. So they are not the only employees, but they are really an important part, and given that significant number. So we looked not only at a survey, but at focus groups and working with law schools. And we also consulted with experts like EEOC and HIE, with those in the university, which sometimes have similar issues of this power dynamic, with employment experts, and also with law clerk groups, including the group that Ms. Shaw represents. And I think the first thing was for the judiciary really to step up the plate and acknowledge the issue, which it did right off the bat. And second, we learned loud and clear from our employees that they did not want an outside resolution or an outside group like an ombudsman, which had been suggested in some of the surveys, but instead they wanted a high level persons within the judiciary. So that led us to create what's called the Director of Workplace Relations. First time ever in the judiciary. We now have those in 11 circuits. And that is someone who is really a freestanding office and individual with significant background in this area, and someone that can help coordinate a number of these things and is not really under the thumb of any judge in particular. We also created the Office of Judicial Integrity, and our recent addition there is Michael Henry, who had been at the U.S. Center for Safe Sports and the issues faced by the Olympics on harassment. So that was one of the very first things done. We also wanted to clarify our confidentiality policy because, you know, the so-called what goes on in Vegas stays in Vegas. We wanted to be clear that if it relates to harassment or an employment issue, it is not confidential and there's free rein to report. The other thing that we did is we changed the targeting of conduct. So of course, Title VII has discrimination, harassment, retaliation, and we broadened that to include abusive and bullying behavior, which is not covered under Title VII. And then we also expanded our bystander reporting, making it an ethical obligation, not only for judges, but employees to make a report when they know of any kind of credible issue. So the other thing we did has been mentioned here is it's really important to have multiple avenues of reporting. If you have a single avenue, which is your judge or your HR person, there are a lot of structural problems with that. So we sat down and we figured out, well, what might we do? And here's what we've done. We've really made kind of 3 kinds of reporting. One is informal, and that's a report that can go to the chief judge of the circuit or the district or the unit you operate in. We have the Director of Workplace Relations. We have our employment dispute coordinators, which are present in every court and court unit. And we also have the Office of Judicial Integrity. So this informal reporting is really broad and there's a lot of places to go. Second, we devise something which we call assisted resolution. So if you go to informal and you're not required to go there, we have no exhaustion requirements, again, unlike the EEOC or Title VII. But if it's not satisfactory or you don't want to go there, you can get assisted resolution. And what we have found is that generally has meant using trained mediators and or chief judges to work with the person who has an issue. And so many things get resolved that way because some of the issues don't really rise to the level of an employment complaint, but they're a dissatisfaction about something, and those ought to be addressed. So this assisted resolution has been really quite effective. And then the third, of course, is a formal complaint. So we have in the judiciary what's called the employment dispute resolution process. And I have to admit, when I first read all those rules, even as a lawyer and a judge, I was boggled by how dense they were. So what did we do? We threw them out and we started all over and made it less complicated, put it in plain English, made sure there was no exhaustion, and made it a lot easier for employees to access the employment dispute resolution process, which can go forward, if appropriate, to what is basically an administrative hearing / trial type setting. And we also trained now, for the first time, these employment dispute resolution officers in each of these areas. And keep in mind that we not only have law clerks and other employees, that we also include the federal public defenders. The second thing we did is we have what's called judicial conduct and disability rules. These are mandatory, actually coming out of congressional mandates. It's a nationally uniform decision-making process and review for an ethics complaint against a judge. An employee can go the employment dispute route or the judicial conduct route, or both, although they don't go on simultaneously, one is stayed. But this was really important to clear up those rules, to include this abusive conduct as part of those rules as well. And I'm a member of that national committee appointed by the Chief Justice. The other thing that was important is that we, for the first time, authorized what I will call a backward-looking review. And that is the ability to look back systemically to see, once you get a credible report and it goes through one of these processes, is that a single incident or is there something broader? So that is really a new tool that we have. You know, other things we've done, of course, is totally revamped websites. We have in the Ninth Circuit, for example, we have a website just for law clerks that lays out all of this plus more other things that are of interest to law clerks. We then did training, and it was important really to do grassroots training with staff and with judges, and it's been in person, online. We're developing also an online training for judges. But now at every new judge training, this is harassment, and all these rules are part of that. At circuit conferences, this has been a very important issue. And at the appellate conference, which unfortunately was delayed due to COVID, it's on the agenda as well. We trained the investigators. Workplace directors have had listening sessions. In the Ninth Circuit, we piloted something called the Law Clerk Resources Group. And this has been almost 2 years old now. And we took law clerks at every level who had clerked, not only in the Ninth Circuit, but around the country. And they served as an additional resource for law clerks. And we found that during COVID, it's not necessarily harassment issues, but employees want, and particularly law clerks want, career advice. And now we have these law clerks who are able to do that. They're out in practice in a whole variety of settings. And finally, we piloted law clerk exit interviews or exit surveys. And we're now, I believe, in our 2.5 year of doing that. And we take a really good look at those results. One thing that I think we should mention here is that the current clerks are almost all COVID clerks working remotely. A few are hybrid. The year before, they were in person and some working remotely. And then, of course, the year before that, our first year, we had clerks in chambers. So I think we're going to have to run this out a few years to see if there's some differences. Let's hope that COVID will decline and that we won't be in this situation again. But it does pose particular issues. So I think that's really a quick overview of where we were and where we've come really in basically 2 years. Enormous changes in the federal judiciary, but we have more that we want to look at and more projects to pilot. And I look forward to this discussion for some additional ideas.
That's great, and really sort of inspiring how change can happen within a couple years, in part because of folks who were whistleblowers, and in part because of commitment by some in the judiciary to really shift processes. And of course, one of the key tests is whether judicial employees, including law clerks, feel comfortable using these systems. Are these systems responsive to the challenges that we talked about earlier? And I'm sort of curious in the perspective of folks on this panel from their various positions about that. But maybe, Liz, we could start with you as someone who works in a law school and is keyed into what recent graduates may be thinking in a way that some of us are not. What do you think about law clerks' feelings about these new processes and systems that have been put in place? Do they seem usable?
Well, what I would say, first of all, let me start by thanking all of my co-panelists, the Brennan Center, the National Women's Law Center. This is such an extraordinary opportunity and such an important spotlight on this issue. What I would say is that, we in the Ninth Circuit, we have all, as Judge McKeown has explained to us, there's a lot of development, and my understanding, and it may be incorrect, is there's uneven development, right? 'Cause it's coming along, it's rolling along, and when I've talked to clerks who've come to me with particular issues that they're having in chambers, they're not bringing up the judiciary system as part of their thought process. It may be that they've gotten formal training, but it's not coming up for them quite yet. So I don't know whether it's just a lack of comfort or lack of knowledge, or maybe they're in a jurisdiction where it isn't as developed yet, but I don't think it's quite hitting quite yet. I think there's still a mindset that it's very all or nothing. That either you complain or you don't, there's a formal process or there isn't. And, a lot of people don't want to give their name. The mentality is, I just want this to stop, but I don't want to give my name. And then they feel like they're in a catch-22, that they can't use the system because they don't understand the creative and informal processes that the OJI and the circuit offices of workplace relations can use to bring attention to these problems or attention to particular judges in a way that won't disclose the clerk's identity. So even understanding that, if enough people report anonymously, that in and of itself can create and spark opportunities for conversations, for further investigations. So I think right now it's because we're at the beginning of all of this that it's not kind of at the top of their minds. I don't know that I don't think it's a criticism of the system. I think it just tells you where we are on the path.
Yeah. And Diva, what do you see and hear from your position as the leaders of Law Clerks for Accountability?
So I'll speak to what I've heard in that capacity, but also in my pro bono representation, working with law clerks and public defenders who are navigating that system. And I think that I'm hearing something similar to Liz, which is a lot of times the people that I speak to, navigating the process is not even the first thing that they're thinking about. It's the retaliation, it's the concerns about what happens if I even speak up. So the question of speaking up itself is difficult. And when they are aware of the policies, it's not the first thing that they go to yet. And I agree with Liz that these policies, I think it's an element of it being kind of new. The policies have been changed recently. They're much clearer to understand, as Judge McKeown was talking about. And I think that they're just not particularly well known to a lot of individuals who are only with the judiciary for a year or two, especially for clerks. And so that can be difficult for people to fully, I think, internalize and understand. But I think there's a separate reason why clerks also are not reporting. And I would say staff members also that I've spoken to are not reporting, which is that the EDR plan is clearer now, but there's still confusion about what reporting means and what sort of confidentiality is available. And so in my representation, I found that people have gotten conflicting information on how to report, whether something will or will not be confidential. If they call into, if they call the Office of Judicial Integrity, you can see Olivia Warren's testimony to Congress. She discussed that she was told that they would not be able to address hypothetical questions, and so that she would have to sort of disclose the specifics of her situation, which might unfortunately, even if it was confidential, it would provide enough information to identify exactly who she was. And so those concerns, I think, can create problems with people and encouraging clerks, especially to report. But then retaliation is, of course, a very real concern. And the cultural norms do appear to be shifting, but I do think there have been judges, for example, there was a judge on Twitter who called out our group multiple times as social justice warriors who were the new coming of the Spanish Inquisition. And it was a federal judge who was saying this to us. And I think that that sort of shift can take away from people feeling comfortable about reporting within that system, especially when many people are told that they can't report outside of their circuit or outside of their district. And then if you have judges who maybe have made comments like that or other comments that make you think that their reports might not be taken credibly, it can make it particularly difficult to even take that very first step of reporting or trying to figure out how to report.
I might jump in if I could, because I think these points are really good. We are at the beginning of a brand new system. And we've made efforts in all circuits to acquaint the law clerks with these systems. And we're going to pilot again this year in the Ninth Circuit, a mid-year update, just to remind people. But I think it's really important, the points made about the need to make sure people know about the system. The only thing we can speak to within the judiciary is sort of the proof is in the pudding, and that is, have law clerks been reporting? And the answer is yes. And so we do know that they're reporting both to directors of workplace relations and also to EDR coordinators and also to the Office of Judicial Integrity. So do we have statistical numbers? No, because there's also that universe who is not reporting either because of fear of retaliation. So one of the things that we are looking to pilot is a two-way anonymous reporting system to see if that would also bring others to the fore, and that we might learn something from that we might not learn from the individuals. But in fact, those who have reported would like to see changes in the system or changes in their situation or want some advice. They really often want advice. How do you navigate a system? And we focused on judges here, judge to clerk, but keep in mind that clerk to clerk is also can be an issue, or clerk to judicial assistant. And then also all the remaining, 25,000 employees who are out there in all kinds of different things. So we're trying to navigate with a lot of different kinds of employees. But I do think it's really important to know that we have to really also navigate with this clerk to clerk issue, which comes up because these are all highly talented individuals who have achieved great things, and some wouldn't mind stepping over others to achieve more. But as I tell my clerks, this may be the one fantastic year where you can't get a raise, can't get a bonus, but you can learn collaboration.
Yeah, I think that's a great point, thinking about the different relationships that require attention in thinking about workplace culture in the judiciary. And just as we're sort of landscaping what are the systems around accountability that exist, We talked about how Title VII isn't an option, but Diva, are there legal options available to law clerks and other judicial employees if these internal systems that we've been discussing don't work, or for whatever reason don't seem viable to the individual confronting harassment?
So it's my understanding that if we take legal options broadly, what it would cover is reporting through these procedures such as EDR and the Judicial Conduct and Disability Act. But outside of those two options, it's my understanding, and a conversation that I've had with numerous officials who work in the judiciary, is that there are not the legal options that we understand as lawyers that exist sort of within the judicial system. And so there's no Title VII, no ADA application, not the typical constitutional protections that are otherwise available in sort of employment contexts involving the government. And so an example I give here is there's a case coming out of North Carolina with a public defender who alleged that she was sexually harassed by a supervisor on her job. This case was dismissed recently, and I think the legal content is correct, I'm sure, in that there are issues with sovereign immunity, there were issues with bringing constitutional claims. The court said that there was no property interest in have the EDR plan's terms as a condition of employment, and that there can't be these freestanding claims under Title VII that can be applied through the Fifth Amendment. And so I'm not here to opine on sort of the legal correctness of that, but I think the purpose of this panel is to talk about whether that's concerning. And I think the posture of the case is concerning, because for a lot of people, even lawyers that I speak to, they're not aware that things like Title VII or the ADA don't apply. In fact, there was 2 years ago, someone at the DC Circuit during a training said that Title VII did apply and had to be corrected by a judge saying Title VII does not apply to the judiciary. And so even people within the judiciary and law clerks who are freshly out of law school don't understand that some of the legal options that they think might be viable in terms of bringing an employment-related suit are just not really an option when you're talking about the judiciary or the public defender's office for that case, which is a part of the judiciary.
Yeah, it's my confession that even though I was a clerk for 2 years and then went on to work on women's issues, including harassment in the workplace for many years after that, it's only been in the past 2 years that I realized that Title VII doesn't apply here. So it's not surprising to hear that many folks don't really know what their workplace rights are when they are clerking or working in the federal judicial branch.
Emily, if I could just add one thing there, I think that can be particularly concerning in terms of optics, because the judiciary is resolving disputes about Title VII and the ADA. And so when you have individuals who are working within the judiciary, I think it can create this sort of confusion for a lot of people, especially those who are fresh out of law school or staff members who are not lawyers. It can be particularly hard because we sort of take some of these protections as for granted.
Mm-hmm. I would just add that the premises of the ADA and those strictures do come into play in the EDR process, and as well as court policies generally.
Yeah, and one question that we've gotten from the audience, Judge McEwen, I'd be curious whether, have complaints continued despite the COVID clerk scenario that you described? Are people still raising concerns?
I would say not what I would call the harassment type concerns, but there have been kind of COVID specific inquiries because it creates a very different environment. And most of those are the kind of things that are worked through with employees or with the judge and the clerk or whatever. So yes, because our employees are long-term generally. So we continue to see the normal kind of issues coming up with them. But I think there is this window of COVID specific inquiries that will pass out of existence at some point.
And since the various processes that you walk through have been in place, do you have a sense of whether people are mostly using the more informal resolutions versus the EDR processes, sort of roughly how complaints break down in terms of ballpark percentages?
Well, I think there are actually, what we have learned is that many employees they wouldn't want to file suit if they could, in the same way they don't want to start necessarily an EDR complaint. And that's why we've been seeing many of the issues come up through the informal inquiry, but stepped up, I think, where there's assisted resolution, because not everything can be resolved in an informal way. And, the employee can actually pursue things on parallel tracks, possibly being no exhaustion. But I think usually what they want to see is they like their workplace. One thing we've learned is that most in the judiciary are very proud of where they work. We are an independent branch of government, so we do have to distinguish ourselves from the executive and the legislative. And they're very proud to work in this branch of the government, and they generally like their jobs, but that doesn't mean life is perfect. So that's kind of what we've seen. I think what we will see when people use the EDR process, that it's easier for them to access and use should they like to go that way. And often what they come for advice is what are my options? What can I do here? And that's where now with these trained EDR coordinators with workplace, they can explain, well, these are your options. These are options you can think about. And they don't have to make a decision right away. They can come back. And often these sessions, it's not a one-shot deal where you just call up or whatever, because a lot of this is in the nature of employment counseling and resolution within, if there's a systemic matter, looking into that. It may not be the first employee. So that's another thing that by having these, like the Director of Workplace Relations, we can start to see, are there patterns that we should look at? But again, as everyone has pointed out, we're new into the new procedures.
Emily, if you don't mind, if just one additional comment, you make a really important point here about how if there are all of these mechanisms and people seem to be using them more, it's the visibility of the mechanisms and the fact that people use them is really important to sort of ensuring that they are effective, because once people sort of have trust that there is the ability to use those procedures, then they're more likely, I think, to use them. And I think that generally when I advise people and sort of my representation on these issues, it's helpful to point to positive outcomes and talk about how EDR has been helpful for other people. I will say that, bringing it back to the question, Emily, we were talking about originally with other legal remedies, I think part of the reason we haven't seen a lot of legal action outside of these internal proceedings is because there aren't very many examples of that being particularly successful, because I don't think that it can be particularly successful under the current regime. And so I think that also makes it difficult to have that be a viable option in the first place.
Yeah, especially given all the other reasons why it's hard to be publicly out there anytime you're experiencing harassment, but especially in this context. So I think the conversation today has lifted up a lot of ways that the federal judiciary has sought to take steps to help prevent harassment, to respond to harassment when it occurs, to shift institutional culture. And there are lots of steps that institutions can take on their own, and there are some that require Congress to act. So let's spend a little time on the path forward and kind of separating out those things. What can the judiciary do on its own? What can others do? What does Congress need to do? So, Hai, what do you think, given all of your work on culture shift within workplaces, what steps can the judiciary take right now to further strengthen prevention efforts, to further strengthen responses to harassment?
Well, I think one of the first steps that all of us outside the judiciary could do is to provide positive reinforcement for all the steps that the judiciary has done so far. Okay. I mean, I think that's just, I mean, think about when you're mentoring someone, right? If they've given you a project, you always want to start with what was positive about it so that, you know, before you go into what more, you know, what wasn't right or what more you could do. So, and I think specifically because even though all of the circuits have tried to do something, I think there's no doubt, Judge McKeon, that the Ninth Circuit has really been a leader. And I think that's really important in terms of saying, yeah, all of you other circuits could do all of that as well. Right. So that's positive reinforcement for those who have done it, and then, you know, best practices for others. But then in terms of steps that the judiciary on its own can take, some of them is just building, in fact, on what we've heard of the Ninth Circuit. The first thing I always say is know thyself. You have to know what's going on. So obviously you want to track in terms of your complaints. But, and I don't know if this is what you were referencing, Judge, but this is a situation where the escrow system should absolutely be able to work. Escrow system means one person can report anonymously, right? You can't do any investigation against someone with an anonymous complaint, but you can say to that person, if someone else reports about that same person, another clerk, a judge, you know, whoever, do you want to be contacted? Okay, because then that person knows there's someone else and maybe they will come forward as two. So very good entity to do escrow systems. To the cultural assessment, I think it's great that there was a large survey, focus groups. Nice first step. What you really want to do as a second one is a much more focused survey, really just for law clerks, a different survey just for some of the employees. You're asking in a way different questions. And then that's quantitative data. And then the qualitative data needs to be from randomly selected groups and employees, because focus groups where people sort of show up for it is going to potentially skew your data. So know thyself. The second is the training. I mean, again, this is perfect. It's about building on the training you already have. So anti-harassment training, very important. But what we have found is having training on respectful workplaces, creating a culture of respect, not harassment specific yet, is very helpful. As one researcher said, disrespectful behavior can be a gateway drug to illegal harassment. Okay, so you start on skills building on what is disrespectful behavior, how can you give feedback, how can you receive feedback about that, and how can you be an active bystander. And then finally, by the way, end all and be all, people have to see accountability. They have to see a lack of retaliation. I mean, you can do everything else, but if that doesn't happen, it's not going to create the trust. And that is both the simplest and the hardest.
So I also want to make sure that we're bringing in law schools as a relevant institution here. Liz, talk to us a little bit about, first, are there structural challenges to law schools acting here? I think there are. And how can these be overcome? What are some of the ways that law schools can be helpful advocates for students and help shift incentives here?
Absolutely. I want to start with, what can law schools do? And I want to talk sort of at the individual level, and then I want to go more systemically. And I want to pivot off what Hai said about the word trust. That really comes up when you hear from a clerk who's in a vulnerable position, who feel isolated, whose thinking may be clouded by serious emotions. They're going to come to the people that they trust, not sort of institutions that they don't know. And so what law schools can do at the very beginning is to build trust during the application process. When these applicants are in school, before they go to chambers, that's extremely important. So they at least have, someone they feel that, oh, okay, if I talk to you, I trust you. We as schools need to learn as much as we can about how our alumni and clerks are treated in chambers. We need to be connected with them throughout their experience, both formally and informally, to be getting some feedback from them. And then as we get information, we need to thoughtfully share it with our candidates and develop a reputation for honesty. In addition, we need to build informational networks and connect our candidates with sitting and former clerks to get their own firsthand experience. We ourselves need to be knowledgeable about the resources and be connected with the directors of workforce relations, with the OJI staff. We need to ourselves build those relationships and know where the resources are and how it works. And I think importantly, when a clerk comes to you with concerns, we need to really listen. A lot of us wear an advisor hat. You have to really take that off and just be in that space of listening and asking good questions and connecting with the clerk's own experience, their values, and letting them decide what's best for them. So I think that's at the sort of individual level, as you said, Emily, there are structural challenges for law schools. Like law clerks, law schools have reputational and relationship concerns. So law schools' clerkship numbers are important, and no one wants to jeopardize them by blowing the whistle, right? In addition, many individual professors have strong relationships with individual judges, and those professors' own reputations can be tied to how well they feed clerks to those judges. So they don't want to see those relationships jeopardized. In addition, alumni judges pose particularly difficult issues as they can be very influential on campus and among their fellow graduates, and nobody wants to be on the wrong side with them. Right? So all of this can lead law schools to put reputational and relationship concerns ahead of the interests of their clerkship candidates and alumni clerks. And I think there's two ways to overcome this. The first is within the law schools themselves, and then secondly, through collaboration with others. So within the law school, there has to be a commitment from the top to put candidates and clerks first. And this message has to be communicated to faculty and clerkship advisors unequivocally. Leaders need to take the long view over short-term numbers concerns. And they have to be willing to have difficult discussions when necessary. And that's hard, but that's leadership, right? Secondly, I think we can overcome these structural barriers through collaboration with others. Law schools don't have all the information, and the Office of Judicial Integrity, the circuit offices of workplace relations, they don't have all the information either. And I think these two groups can work together. I'd love to see more collaboration and information sharing among the law schools and these judiciary offices. And I think we can do this in a way that's sensitive to the law school's structural challenges. Just in last year, right, as Judge McKeown was saying, the circuit, there are now directors, OWR directors in all the circuits. And the departments, some of them are very, very established, like in the Ninth Circuit, others are just coming online. And I think this is the perfect time to think about how we can bring these groups together to move things forward collectively.
That's great.
Emily, I'll just add one quick point from having been, I guess, perhaps the most recent law student. I'll say that it is the structural challenges for law schools and the judiciary are tough, but I also think that there are a lot of concerns about who holds the information here, and law students tend to be the least likely to hold any information about what's happening. And this can negatively affect, most likely, people who are first generation, people of color, students who don't have access to the same professional resources that many other individuals might. Getting information about which judges might not be a great fit for you or might not be a great fit generally for a law student sometimes can be quite difficult. And some law schools tend to have a lot of that information based on how many clerks they have, and other law schools don't have that information, which is then combined with access for those students. And so I think the escrow comment that I think Kai mentioned before is something that is also an important consideration between law schools and the judiciary, because they hold a lot of this information, and it's difficult for many reasons, I think, to pass that down on to students, but the students shouldn't bear the burden, I think, of that concern.
And I would love to follow up with you on that, but I know we need to take a little
Yes.
break, so I want to hand it back to Emily. But I would
So
love
can I weigh in, or do I have to wait on that point?
Let me do the CLE housekeeping code and then you can weigh in. So for those seeking CLE credit for this event, please record the following code on your affirmation sheets in order to verify your attendance. The code is HMJWD4. Again, that code is HMJWD4. So Hotel Mike Juliet Whiskey Delta and the number 4. Judge McEwen, please.
Yes, well, I just want to echo everything that our great professor said, because early on, we reached out immediately to the law schools because we realized where do law clerks come from? They come from law schools by and large. Some come from practice, but they've all been in law school recently, as Ms. Shaw mentioned. So we reached out to them. That resulted in us working with the American Association of Law Schools and also the National Association of Law Placement. But we had hoped for a more robust response. And I'm now hoping that that will start to come, because the schools need to be candid with the judiciary if they're seeing systemic issues. And we now have a structure where that information can come through. But in speaking with a number of deans and professors, they, of course, face the dilemma that was mentioned, and that is they want to get people into clerkships. But the worst thing to happen is to get the wrong person into the wrong clerkship. And so there's a lot, I think, can be done within the law schools. And we were hoping for really more systematic seminars, training on this whole issue, because it doesn't affect the law schools, not just in clerkships, but they're going out into the larger law world as well. And these same issues are there. So I think the law schools have so much to offer. And I know that we're beginning to work more closely with some of them now, and we welcome all of them to reach out.
And if I can, Emily, do you mind if I follow up just to engage with Diva on the point she made before the judge spoke? Is that all right?
Of course, yes.
Okay, so I agree with you, Diva, 100%. That a lot of students, we can't assume they're plugged into the conversation or aware of what questions to ask. Some students are so self-made, they don't think to come to advisors for help. Others have never really benefited from informal networks, so they don't understand the value and importance. So I think we have an obligation to build fail-safe plans and backup systems that don't rely on the applicants to come to us. We have to go to them. And so, for example, something that you can do is you can periodically review which judges your candidates are applying to, and look at, are there any red flags? And if there are, then do affirmative outreach to those candidates to say, hey, I need to share some information with you. I also think transparency is so important. Whether you're in front of large groups or you're in one-on-one conversations, you need to make clear you're going to put your candidate's interests first, and you're going to be honest with them. It's back to the concept of trust. And I also think we need to do as good a job as we can reaching out to our affinity groups to help them plan clerkship programs and increase our ties to those groups of people who are first-generation law students, first-generation college students, students of color, women students, all kinds of student groups, to strengthen our ties both to the individuals and to those groups as a whole. So I do think the burden rests on us to be going to our students and not assuming they're going to come to us.
Liz, I think that that's a really important and great point. And one thing I'll point out is I think it's great that you're looking at these lists that you're making for red flags, but it, in some way, to me, it's at least emblematic of the problem as well, because the fact that that is the level at which we have to hope that information is getting to students, and I think that being a graduate of a T14 law school, I know that I probably have more of a chance that someone will know about that red flag and point it out to me. And so I just, the fact that that's how red flags sometimes come to the attention of law students is a concern in and of itself, of course. But I do think that in the meantime, this is a helpful way to get to that problem. But I think it's important we're having this conversation because the fact that these are sort of widely known red flags sometimes is very concerning as well.
And to go to what Hai was saying, doing that sort of anonymity and creating more opportunities for that information sharing through the judicial efforts of Judge McEwen and her colleagues, I think that's where we can really, see that accelerated success.
I want to make sure that we have time for questions from the audience, but before we go to those questions, the one last question that I would raise to the panel is, are there steps that Congress should take to do some of the things that institutions can't or don't want to do? Welcome any of your thoughts. Diva, Hai, I suspect you guys have thoughts on this question in particular.
Well, actually, maybe I'll start to pick up on some of the conversation we just had, okay? To be strategic and intentional, we have to find all the levers that need to be pulled in order to make a difference here. The law schools, the law clerks, current and former, the judiciary, okay? And some of this stuff takes money. It takes resources. If Congress wants to help, to me, the first thing they should do is offer money. No, really. I mean, in terms of the additional training, in terms of the cultural assessments, in terms of, if you had one person at the judiciary who the whole job was to work with one person at AALS, to do this, I mean, we need to put our money where our mouth is, including Congress, when Congress says we want this to change. And I think the other thing is Congress, you have to look and identify the things that judiciary cannot do on its own, right? Outside legal, remedies, whether an outside monitor works. And I think you just have to be thoughtful on how to do it, right? So you might think immediately outside monitor, yes, for some reasons, no, for another. Let's be real about having the conversation so whatever gets done works.
I'll add that I think there needs to be a serious conversation about protections through Title VII and the ADA. And I know there are real concerns about that, but if the EDR plan covers them to some extent, I'm not sure why that legal remedy would not be an appropriate add-on to sort of provide that avenue so that people understand that there is legal ramification for those violations. Judges, I think some of the conversation I've heard about this has focused on how judges would have to rule publicly on other judges' actions or conduct, and that might be a concern as well. But our current system under the Judicial Conduct and Disability Act and the EDR proceedings has the same kind of concern and is still functioning, and I think it would face the same level of concern. So I would just say a more serious look at what statutes apply to the judiciary is important. And I know that there are significant concerns there, but I'm not sure that there's been as many conversations about that. Protections for whistleblowers should be, I think, written into law and should not just be a part of these EDR proceedings. And then also, I have concerns about whether a judge's resignation or retirement ends up mooting investigation or the ability to bring suit. And I think that there have already been changes made to the Judicial Conduct and Disability Act to cover this, but I think that there needs to be more acknowledgement that has been a way to avoid accountability in the past, and that if that's used as a reason to not bring suit, that can be of concern as well. Finally, I think that Hai is right, that money is important here. One of the best things I think that can happen is a national climate survey and public reporting of demographic information. And I know the panel tomorrow for the Brennan Center will get into this, but a lot of these issues are tied into diversity and hiring and making sure that we have, that's one way to address discrimination and harassment is to have those numbers available. And so there are a lot of different things to consider here. And I know that there are concerns, but I think the conversation should be more open about whether these avenues are possible and what the concerns actually are, because I would hate to see Title VII and the ADA not apply, especially when, if the EDR plan is already covering those aspects, I don't see much of a reason why having that extra signaling even would not be important here.
I want to give space in case others, Liz or Judge McEwen, if you all have thoughts about what actions Congress should take or could appropriately take. Otherwise,
Sure.
Go ahead.
Well, I think that two things. One is, of course, you have to recognize the independence of the judiciary and to give that the appropriate play. But that said, the judiciary is in constant contact with Congress, whether testifying, as recently happened with the Director of the Administrative Office, Judge Motzkoff, or prior to that, Jim Duff, and also in touch with a variety of committee staff members that deal with these issues. So there is a dialogue between the judiciary and Congress, and I don't want to let the panel leave without an understanding that so much of that is happening in Washington already.
So I want to make sure.
I was going to say, I can attest to the fact that that is happening, having been called by some of those staff. And I think it's building on what's been going on.
I want to make sure we do have some time for some of the great questions that we are getting from the audience. One thing that I did want to flag is a comment from Elizabeth Parrott, who's an executive for the District of Columbia Circuit in the U.S. Court of Appeals, who says that the Title VII DC Circuit training story is not exactly right, that instead that was a conversation about what the judiciary can do to protect a complainant's identity and whether there's an obligation of the courts to report a rape or other criminal activity that occurred in the courthouse, that it wasn't exactly a conversation about Title VII's application. So you wanted to raise that up for the record. But shifting to questions, one really interesting question, which I think that you started to speak to, Judge McEwen, is there a plan for embedding system-wide training on these new workplace harassment policies and processes as new judges are onboarded? And is there also a plan or already in process system-wide training for new clerks when they come on board about these policies, as well as all the different options for more formal and less formal reporting or seeking of support and help?
Yes, I appreciate that question. To begin, we already have a system-wide training through our Federal Judicial Center, which is a very professional training and workshop center. And we have both new clerk training that happens immediately, usually in the August-September period. And we also have for all the new judges, and there have been quite a few new judges appointed, in the recent number of years, and those trainings will continue. So every new judge gets that training. And I might also add that, when you say you're going to train people on workplace harassment, that may not actually bring them with excitement to the training. And we recognize that. So really what was mentioned here is what we're talking about is training on a culture of respect. And embedded within that are the procedures and all the rules. And the other thing that's become important over the years, and we're trying to emphasize, is that judges are managers. It may be a very small law firm of 5 to 7 individuals, but judges manage their dockets and they manage those that work with them. So we're providing a lot more resources in this regard. So there is training at the national level. We have 3 district court workshops every year, and these issues are on those workshops. And then in addition, the circuits have been having this as a very prominent topic in both district court workshops and also circuit-wide workshops.
And are judicial externships covered by OWR processes and these other processes as well?
Yes, an excellent question. As we tell the externs when they arrive, is that you have all the benefits of being privy to the confidentiality of what goes on in chambers, but you too are covered by the ethics rules and also by all of these employment rules. And you also have the options in terms of recourse under these rules. So very important for externs because they're coming to us from law schools.
And hi, following up on your comment, which I've heard you say many times and remember it well, because I think it's a really great insight that abusive and bullying behavior is sort of the gateway drug to harassment. How should we define abusive and bullying behavior? What do you think of when you think of the efforts necessary to shift workplace cultures away from that behavior? How do we define that?
Well, actually, the fact is, even before bullying, disrespectful behavior, just the small things like interrupting someone, ignoring someone, not giving someone credit for the work they've done, right? I mean, those small things, I mean, the science shows when you get those sort of cues, there, because your brain is always scanning for risk, because our brain was created to protect our physical body, not that we think about it that way. So it's constantly scanning for risk. And when they get cues like that, the brain releases adrenaline and cortisol, and it makes us hyper and stressed. And we don't even know it. And actually, when we see rude behavior to someone else, those same hormones get released. So it's sort of stopping that disrespectful behavior, just yelling at someone when the draft of the opinion wasn't good. Okay, that's the disrespectful behavior. The bullying is when you're doing that over and over again to one person. You're constantly undermining one person. But what you want to do is stop the disrespectful behavior, to explain to a judge. It's very important because that person has so much power that part of being a manager is acting with respect. And the same thing for the clerks. As Judge McKeon said, some clerks think they are just fantastic, and they haven't been trained in respectful behavior. So, I mean, the way we do it is you explain to people why they should care, explain the toxic impact that even small behavior has, and then give them training in how to give feedback early on to stop it or receive that feedback if they give it, and how to intervene as a bystander. And then the additional set of skills that go to supervisors is how do you listen to a complaint when it comes in? Because that's the most important moment, is when you first hear the complaint. And then how can you coach someone who's engaging that behavior? So it's like the social science is out there about how to do this well. It's about making it of value. And once you do that, by the way, it's then very easy to explain harassment. Bullying is like really obnoxious behavior, but not on any status, equal opportunity bully. The harassment is any unwelcome behavior, even small behavior done because of someone's race or sex, right? So if you stop people from doing the disrespectful behavior, the interrupting, the undermining, the yelling on any basis, then they're not going to do it on a protected basis either, hopefully, or at least they'll be stopped. So that's the thumbnail social science there.
And this is an interesting question, which had not occurred to me, but someone asks, with the limited legal recourses available for law clerks, relatively speaking, have there been efforts to unionize clerks? Not that I know of, but does anyone know whether that's been a conversation, or even, again, I'm not sure how the NLRA applies to the judicial branch.
I will say, having had many conversations about sort of what can be done on these issues, this is one that does not come up particularly frequently. And I think a large part of that is because the turnover is so fast and quick. It would have to be something at the least led by permanent clerks or staff members. We have not heard from permanent clerks or staff members that this is something they're interested in, and having that union just, I think, is it has separate concerns as well, with regards to confidentiality and other issues, but it just hasn't come up because I also think that in order to get to that place and to have that conversation, there needs to be these conversations first, having open conversations about the problems that exist. And so I think the union issue hasn't really been as much of a concern as much as how do we get information about the procedures that do exist to students and law clerks. And then once they have that information, is it a system that they're willing to use, that they're comfortable using it, and sort of what barriers are there to reporting before we even get to the question of sort of how do we all collectively then work together, and whether a union or some other format here might be helpful. I just think we're not quite at that place yet.
I also, just very briefly, because I meant to say this earlier and I did not, I also think that the judicial clerkship 1 year term, it makes this different than everything else. Because if you're in an employment situation for the long haul, that's so different. And our law students have incredibly high tolerance for discomfort. And our associates from big law firms and people who are coming from very, stressful public sector jobs, all of these people have incredibly high tolerance for discomfort. And if it's just a year, you just white knuckle it. You just hold on until your term is over, and maybe you're making X's on your calendar, and we don't want people to have to live that way. But I think that makes this that much more difficult because people can just hold their breath until it's done.
Also, Emily, I'll just add kind of relatedly, what you mentioned earlier about Title VII in the DC circuit. I think that there is a concern here. I didn't mean to imply that that was actually the statement. I think that students left, or law clerks left with the impression that Title VII might actually apply to them, or that there was confusion about whether it would. And I think that before we sort of get to what can law clerks do and can they unionize, I think that a bigger question needs to be, well, what kind of information do they have, and do they fully understand the remedies? And I think law schools are a very important part of that, and giving them those resources to sort of answer these questions is probably the first step before we think about what can law clerks themselves be doing.
Well, I am sad to see that we are out of time, since there are more really great questions, and I've really enjoyed this conversation and appreciate all of you being willing to engage with each other and build on each other's thoughts in ways that I at least have found really helpful in how to think about these tricky problems and what solutions are out there. But I think we have to wrap it up right now. So I'm going to say thank you to all of you for joining, for the panelists, for our audience. Thank you for coming to this event and participating in this lively and urgent discussion. For those seeking New York State CLE credit in the Diversity, Inclusion, and Elimination of Bias category, you can find the link to the attorney affirmation form and associated reading in the Zoom chat. And it's also on the Brennan Center event landing page. And if you have any questions about that, please contact cle@brennan.law.nyu.edu. And that's also going to be dropped in the chat, that address. We hope that you all will join us for tomorrow's panel discussion about how current hiring practices have led to clerk classes that lack racial and ethnic and gender and experiential diversity, and how that could be changed. But for today, I'm Emily Martin, and I want to thank you all again for supporting the work of all of the sponsor organizations, including the National Women's Law Center and the Brennan Center for Justice. Thank you all so much.
Thank you.
Thank you.
Thank you.